Welcome to the Resolution Room with me, Mike Gaston. The Resolution Room is a monthly podcast on behalf of Mediation Northern Ireland and Ulster University, where we explore the uses of mediation in conflict resolution and peace building. This episode, the fourth in the series, is on mediation in legal practice, and in it, we'll talk about how mediation fits into legal practice here, how mediation can help resolve sticking points in the legal process, and the risks and potential benefits of using a light, mediative approach in legal cases. To help us do that, I'm joined by Dr. Esther McGuinness, Head of School of Law at Ulster University, and John Keers, Lecturer in Law at Ulster University. Esther and John, you're both very welcome to the Resolution Room. Where I'd like to start this conversation is perhaps by exploring a paradox. And the paradox is in the difference between pure mediation and pure law, in that pure mediation is about working collegially for a win-win situation, and pure law is about an adversarial situation where you're looking for a win-lose. So how do you incorporate that into your practice of law?
Do you want to go first?
Sure. So I think I come from a bar background as a barrister. So within that, I was able to witness the power of trying to negotiate, trying to find a way to save the adversarial process from having to take its full course. And that got me a little bit curious about mediation. And subsequently I qualified as a mediator. So I think it definitely has a role. I don't think it's utilised sufficiently, if I'm talking honestly, from the bar background. It tended to come very late in the process, and in some cases it was more like a negotiated outcome rather than a true mediative process, because the dispute had got to such an entrenched position.
And hopefully we can come back to that. Esther, what about you? You're also a trained mediator.
So I'm going to give you a 2-point answer to that. The first one is I come from a trade union background, and I think that whether some of my trade union colleagues would agree with me or not, settlement is always key to what we do. Secondly of all, I'm the second youngest of 9. So mediation skills, I think, are key to good family relations, and you learn that very early on around the kitchen table.
Although I suppose you could argue sibling rivalry plays a part in that too.
Well, the sibling rivalry had played out by the time I came along, I think, so that made it all so much easier.
But there is a difference in the application of mediation and law. For instance, when I was being trained as a mediator, and it's still the case today, if we come into a situation where there's a legal process already in train, as mediators we pull out, leave the legal process to conclude, and then think about coming back in. What's your experience of that, Esther?
Well, we do quite a bit of mediation in the law clinic, and I think that there is obviously a role for both. In many of the cases that we support in the clinic, they should never have gotten to the stage of legal proceedings. And that's really unfortunate. And there is a role for law, absolutely. There are some issues that should not and cannot be settled on the steps of a courtroom, and that do need to go in to court to be settled on a point of principle and a point of law. There are many, many other cases that we support in the clinic where there has simply been a breakdown of employment relations, people relations. And there is lots to be salvaged for both sides. And for me, that is key, and that is one of the things that we do very well, I think, in the law clinic.
Thanks, Esther. I'm very keen to find out what it was that attracted you to using mediation in your legal practice in the first place.
From my perspective, it was because we had simply so many cases coming through the law clinic, many of them employment law, an increasing number of family law disputes that we were being asked to advise on. but primarily employment law. And in that instance, it was very evident to me, as it had been certainly from my days in the union, it was very evident to me that what had happened was that simple employment procedures had not been adhered to, and had not been adhered to for a very long time. That allowed relationships to fester, and there was an element of basically grudgement that had taken hold, that found those parties becoming even more entrenched and forgetting what the overall legal problem was, and just becoming entrenched on the basics of relationships. And I realised at that point that there was lots that we could do in the clinic. And there was actually a willingness, because by the time cases had come to us, excuse me, they'd been everywhere else. There was nowhere else for them to go. And people were mentally and physically exhausted. And mediation actually provided respite, I think, from all the perceived battles up to that point. So it was really important to me at that point to embed mediation into what we did.
And you found it possible for parties to put their grudge behind them and focus on the process?
Absolutely. I think that all lawyers, and indeed many do now anyway, but I think all lawyers should train as mediators, because it provides an alternative view on a case and the details within that case. And it puts the parties and the issue at the centre of it. And I think that's really crucial.
Thanks, Esther. John, when you were going through your training in mediation, what were the fundamental learnings you got that you could apply to your law practice?
I think it made you look at the dispute a lot different earlier on, in particular, to look at not everywhere, as Esther says, not every matter that you come into and advise on is appropriate for mediation. So I suppose it's about learning about where is it appropriate, and even even if you miss the sweet spot or where it would ideally be, it's about maybe looking at it and saying, well, okay, it's not appropriate at this point, but we need to keep an eye as to whether or not it becomes appropriate. So that could be a softening of the position between the parties. That could be your client or the other party. Maybe taking a slightly different view of it, or maybe signalling that they're ready to sit down and to perhaps mediate a solution. So I agree 100% with Esther. I think everybody actually should qualify as a mediator as part of the process of maybe qualifying as a solicitor or a barrister, because it's a key skill set to be able to learn to look at and to think about what is in the best interest of your client, which ultimately is your role if you're advising somebody.
Thanks, John. What I'm hearing you both saying is it's a case of getting beyond the grudge, the personal grudge, to working more collegially to find a better solution. How do you achieve that?
I think you listen first. I think that mediation requires a great deal of empathy. An understanding that if people have agreed to mediation in most cases, not in all cases, and we'll maybe come back to this point, but in most cases where people have agreed to mediation, they want an alternative settlement. And I suppose what's important, I think, is as a mediator in the first instance, is to listen and to understand where those parties are coming from and where that hurt is, if I can describe it in that way, because usually by the time people come to mediation, there is a great deal of hurt and resentment built up. And it really is, for me personally, about understanding where those parties are coming from and to try and understand where that resentment began. And listening to the parties as they articulate that, possibly for the first time, in a very different, non-adversarial way.
Do you know, I'm listening to that, and part of me wants to ask you now, tell us how the law clinics developed at UU?
So the Law Clinic developed about 13, 14 years ago as the brainchild of some of us who realised that there was a huge number of litigants in person before Social Security and employment tribunals. And so it was established with that in mind, but also we wanted to create an alternative form of learning for our students. And we realised at that point that many students after their law degree, bearing in mind that this was kind of post the recession, if we've ever really come out of it in, 2007-8. And so ideas began, I suppose, fermenting then, percolating then maybe. And we realised that lots of students after their law degrees didn't really know what to do. They couldn't get a pupillage. There wasn't really the legal sector, and I use that term deliberately, wasn't as developed as it is today. And so there were fewer jobs. And they were doing it seemed to us that they were doing any sort of law masters to kind of kill a year. And that was the phrase that came back because we did provide a questionnaire to our final year students anyway. And we wanted to provide them with some meaningful training. We wanted to support our community partners. We wanted to provide an alternative source, I think, for support and advice and representation. And so the Law Clinic was born from that. It began really focusing on employment and social security, but it has now expanded into other areas as a result of the need for individuals to access justice, and that is paramount always. So it has expanded into other areas such as migration and family law. And we do have a small commercial clinic that helps new startups. And essentially what we do, and it's very important to say this, I think, is that we work with the legal profession, not against them. So it's completely pro bono, and it's advice where there is no financial gain in it for law firms.
That sounds absolutely fabulous. I'm going to come back to that in a second. But using a term that you used, pupillage, I wanted to check with John. When you were going through your pupillage, was mediation on your horizon at all?
No, never talked about. For my personal journey, it was quite different. I suppose I could see the efforts that were being made around negotiation, trying to find settlement. My practice was mostly in commercial law and chancery. So Esther talks about, the last recession, 07-08. We were still clearing out in 2014 cases around the likes of Order 88 proceedings, around where people are having their homes taken back by the banks, and a totally inappropriate process where people were locked into this dispute over 6, 7, 8 years, and it still hadn't gone to trial or hearing. Personal relationships broken up, marriages broken up, family members not talking to each other, suicide, all sorts of issues that were caught in this. So you couldn't help but look at it and say, look, there must be better outcomes than this. And I suppose that curiosity led me to the doors of Mediation Northern Ireland eventually, to qualify as a mediator and learn more about it. And I think that's why, I mentioned earlier on, I think it actually at this point has become more mainstay and therefore should really be part and parcel of what students learn about. And we have tried to do a lot of work in this with our undergrads, looking at the alternative dispute resolution methods so that they're at least aware of them. But why not have that as a core principle within qualifying as a practitioner, either as a solicitor or a barrister? I think we're getting to that point where it should actually be that straightforward. It should be at the core of what we do, simply because of the strengths it gives us to look at a dispute in a slightly different way rather than just pure adversarial.
And looking at that 7 or 8 year process, John, that you've just described with the fees ramping up all the time.
Yeah.
That's why I was delighted to hear Esther talk about pro bono, because at the end of the day, when people are in desperation, they're watching the money tick up and they're going, how do I get out of this?
Yeah, and I think the Americans started talking about 5 or 6 years ago about, rather than alternative dispute resolution, they talk about appropriate dispute resolution. I actually think that's really important to think about, because the reality is what we're seeing across, and we're not unusual in the UK or Ireland, the bottom 20% of society can get access to good legal advice through legal aid and other methods. The top 10% of society can afford good legal advice and representation and not need to worry about it. But everybody else, that 70% that's stuck in the middle, need to really worry about it. And I don't know that people really understand, to have access to the courts, what that's going to mean for them. It could mean them remortgaging their home so as to be able to pay for the fees. So again, we've got to start looking at our justice system and thinking a little bit about, how do we make it accessible? How do we make it appropriate? In what circumstances is it correct for a party to be taken down an adversarial route rather than perhaps a different route, such as mediation or some other method to try and resolve the dispute quickly and appropriately?
That's very encouraging, John. Esther, I've also heard you say that the law clinics aid access to mediation for potential users. So we've talked about the financial a little bit, but what other ways do the law clinics aid that access?
Well, I would say John and I qualified together as mediators here with Mediation NI. It was probably the best training I ever did, I have to say. You could tell me any sort of bad news on a Wednesday. And I think it was useful that we both trained and qualified together around that time. I think we had very similar aims. And just to give you an illustration of that, since John and I have qualified, we set up an ADR module for our undergraduate students. So that's on our main LLB program. We work very closely with the LRA. In fact, they deliver 6 weeks of a module that I deliver on employment law. John set up a summer school, mediation summer school. So mediation has been really fundamental to what we do, from undergraduate right through to postgrad, and then what we offer with our community partners. And we work with a huge range of community partners. And I would like to think that when our community partners use our services, that what they understand that they're getting from us is a service that is overseen by people who are qualified, but delivered via students who are closely supervised. And the quid pro quo is that we are pro bono, so it's the learning opportunities for the students without any cost to those individuals or those organisations that would use our services.
Sounds to me like the law clinic at Ulster University is a win-win. It's a win for your students, it's a win for your potential clients, and that's very encouraging to hear. Moving on to something I've picked up from John. Why do you believe that mediation should become more mainstream in legal practice?
Well, I think inside and outside of legal practice, actually, Mike, it needs to move from being, I suppose, what we would have witnessed maybe 10, 15, even 20 years ago as a sort of nearly like a cottage industry. It was very ad hoc. And one of the things that we we met recently with partners down in the Republic of Ireland, so as to look at the whole Ireland context. And out of that, we put together a programme for last October, which looked at whether or not legislation is required. And certainly in the Republic, they have made great strides in that front. So it's about what can we learn from that. And since then, we are engaging with the Department of Justice to look at trying to put together a steering group to look at legislation, what appropriate legislation is needed for Northern Ireland. But the real thinking behind that is twofold. One is to try and take it away from just being a cottage industry, try to make it more mainstream, both inside and outside our legal process. But also, we, I suppose, at the law school have become a stakeholder in all of this, because we are producing 20 or 30 qualified mediators every year through the summer school, which Esther's mentioned, and through the master's programme in international commercial law and ADR. So we've got to think about that and to say, well, okay, these students are now qualified, but where are they going? What are they going to do? Are they going to be able to go into practice as mediators? Have we made that pathway? So I think, so from those two aspects, I think, Mike, is really important. One is the legislation side, and then the other side is the pathway to making this a professional choice and career for people, rather than just a sort of more cottage industry approach.
Okay, we've used the term cottage industry quite a lot, and what I want to do is get some clarity on that from you, John. What did you see, or do you see, as cottage industry in mediation in law at the moment?
Well, how many people in society actually know about mediation? That's the point. That's why I call it a cottage industry, is that, yes, it's going on in little pockets in different places, but we need to make it more mainstream, that people understand it, people understand what they're going to get from it, and that it's just, and that's been supported where it's appropriate from government as well. Do we need to look at how it's funded, for example? And should more funding be made available in certain circumstances, such as family law, where mediation has a real role, in my view.
And throwing this open to the floor, looking at how we go forwards, how we develop the legislative models to make this more helpful. What do we need here in Northern Ireland in terms of legal framework to make this happen?
Well, legislation would be helpful. It provides a set of guidelines, a framework in which people engage in mediation. It provides better structure for everybody involved. It maybe regulates it to an extent in terms of cost. And it then brings it into the wider legal forum, I think. Yeah. So that it's recognised properly as it should be. And mediation has been around for a long time. I think it was developed by the Justinians. Others here may correct me if that's incorrect, but
China.
I think around I think it was 530.
Yeah.
Well, the Justinians might claim, the clue's in the name, might argue that they were first, but I think it is something that is within almost everybody. So people, once you explain it, understand the concepts. But I think bringing that into a legal forum in a legislative way provides better guidance, it provides better regulation and more security, I think, for both users and for those who are managing mediation processes.
To make this a bit more obvious to me, what would legislation for bringing mediation into mainstream, what would it look like? What would be the primary principles?
Yeah, well, I think I don't want to be too prescriptive about it, because I think in actual fact it's important to start the journey together with all the stakeholders, and we're only really at the start of that. We've discussed the concept with the Justice Minister, who's very supportive. So I think it's about bringing together those, because the Law Society, for example, the Bar Council, Family Mediation Northern Ireland, all of these different parties that are operating in Northern Ireland and have an involvement with mediation already, all need to have a voice, and to find a way forward. As Esther says, perhaps regulation is going to be something that's key when we think of barristers and solicitors. They have governing bodies that make sure that they keep within the guidelines and keep everybody safe. And I think that's really important to look at that piece as well and to try and find common ground. So I think when we talk about legislation, it's about having that discussion. The discussion's not even happening yet. So when we look at England and Wales, those discussions are well underway, and aspects such as, and again this is controversial, but aspects such as compulsory mediation, for example, compulsory in the nature of they need to be informed about it. We can't make the process compulsory in itself. But in England and Wales, that's moving at stealth. In the Republic of Ireland, we see legislation moving, and what's more, what brought with that legislation was public funding, appropriate funding for the likes of family cases. And we just need to get these discussions underway so as to see what's appropriate for Northern Ireland. We're a small province, but there's no reason that if we get these discussions underway, that we can't actually lead the way. That's what we should be doing, and really look at how do we change the way we're doing things at the moment, and how do we regulate, and how do we make fund it appropriately.
And I was going to say, sorry for interrupting, Mike, I was going to say that elements of this exist. We don't have to reinvent the wheel. Family mediation exists for a reason. Obviously, parties come to that voluntarily. And maybe there is an issue. Well, I think there is an issue. People may see that if we legislate for it, then it becomes a mandatory matter. There are certainly ways of managing that. They do it in the UK, they do it in the Republic of Ireland, and actually we do that here in family mediation. So the bones already exist, and there is a willingness, and particularly here in this jurisdiction where there is such issues over access to justice and lengthy waiting lists on absolutely every public service. It is a no-brainer to create a legislative framework and a funding track that would alleviate some of the issues around legal aid.
The impulsive part of me is saying, okay, so when do we start the process? When do we start talking to the parties and get the ball rolling?
Well, the Justice Minister's already given an indication that she wants that done. So we'd be hoping that those discussions to get the working group or steering group together and get those parties together will be happening imminently. And then we just see how we don't want to rush a process. We want to get the process right. We want to make sure the legislation's appropriate and leading the way. So that will take its course in a period of time. But I think just touching on Esther's point about what we're witnessing at the moment is huge backlogs. You keep hearing about it every so often. Something will happen. I'm curious about it myself, and some of my research is looking at this. For example, when we look at countries like Brazil. So Brazil has an 80 million case backlog. We walk in today to put our case in, it's 80 million and one. So how do you address that? How do you make sure that people have access to justice? Are they going to wait 30, 40 years for the case to be heard? Is that appropriate? Or do we need to rethink what we're doing and how we're approaching it? Do we need to, and this is a bigger question for our courts as well, to what extent are the courts suitable for a lot of disputes today? And how do we crack these long waiting lists? How do we crack helping litigants in person to appropriately go through the justice system? And, some of the work that Esther's talking about and colleagues of ours at the school have done huge elements of work in this and trying to shine a light on better processes. I believe there's probably some technology solutions as well that need to be looked at and developed out, and that's something at the school that we're looking very closely at and through the Centre for Legal Technology.
I'm going to leave that one hanging, that question hanging, John, and move on, because there's a couple of areas I think we need to look at before we wrap today. And one of those is how affordable is mediation in the legal process right now?
Well, mediators and mediating bodies or groups will have their own funding, but, if we were to cost out, if I can put it to you like this, yesterday I was thinking about tracking how many pro bono hours our students had done in the law clinic this year. And we base that on the Law Works hourly rate, which is a kind of governing body for pro bono law clinics. And we base that on an hourly rate for paralegals in London. That's what we're told to do. And interestingly, yesterday, I just checked what that hourly rate was, and it was from 129 to 169 pounds an hour for a paralegal rate in London. An hourly rate for a mediator here is possibly half that. And it can be significantly more, particularly if you're working with high net worth individuals and it's maybe a construction issue or something similar to that. But what I would say is that those costs are dwarfed by the cost of legal proceedings once they commence.
So is part of the answer to look for trying to get appropriate funding for mediation in the legal process?
Yes, in part. I think it's not only do we need that legislative framework, as John and I have said, which exists elsewhere, but it is about redirecting monies, not taking away further from the legal aid bill or the legal aid fund, but of thinking more creatively about funding alternative means to dispute that can bring about a better resolution much more quickly. And in the round is a much more healing process for all parties involved. And remember, we come from a post-conflict jurisdiction, and where lots of people think that they have to fight for everything and want to have their day in court as a point of principle. Mediation slowly breaks down all those myths, and it's by its very nature more conciliatory. And so the process in itself can be quite healing for all parties involved.
What I'm discovering in this conversation is that we're almost in danger of doing a podcast light here, because there's so much more that we could explore. But I'm just going to dip into one final area of discussion, which touches on that light approach. And that's, John, I've heard you use the phrase mediation light. Can you say a little bit more about that?
Have I? Well,
you're on record.
I suppose what I'm talking about is what I've witnessed from the bar, which is going to sound very critical, and it's not meant that way, but a different style or approach to it, where you've got this sort of shuttle mediation going on with a very senior mediator who's perhaps been a High Court judge, for example, who's retired, and through that process, they're just sort of like nearly banging heads together to try and get a resolution, say in a commercial case or something like that. That stands in stark contrast to what the likes of Mediation Northern Ireland or Family Mediation would, as organisations, set out as their sort of gold standard in mediation. To a point where you'd maybe nearly argue it's not mediation, what I've just described previously. So mediation light, that's what I mean by that. It's not the full process. And indeed, even where mediation is used within the courts, I suppose it has to be adaptive to the circumstances of the dispute. And so where they find themselves, to be fair, is in a very different space. So where Mediation Northern Ireland might start out with one of their mediators in a dispute is going to be very different from where counsel is going to find themselves 5 years into a dispute where they are desperately trying to find a better resolution rather than heading to the in for trial, where really, you've got to explain to your clients, while yes, you wouldn't have recommended going to court if you didn't feel they had a case, but ultimately going in through the doors of the court, you don't know what's going to happen. You don't know how that's going to play out, how evidence is going to be presented. And there's pros and cons to that, but there are certainly weaknesses that need to be set out. Talking to Esther's point in relation to people want their day in court, that's not my experience. Show me somebody who's about to go into court in the High Court who's excited about the opportunity to go into court. I've never met them.
What about the people who think they're going to win?
Well, can you be sure? Can you be sure? I don't know about that. Like I say, I certainly have never met them, these people that want their day in court. I think what they want is the dispute dealt with quickly. I think they don't want to have to remortgage their house to do it. I think they want to be able to do it within reasonable means. And, you mentioned earlier on about what does it cost. And I think there's a growing chasm between what you would maybe get as being paid as a mediator in Mediation Northern Ireland or Family Mediation or Global or some of these other firms that operate in Northern Ireland, and what's being charged in the likes of a commercial dispute by a retired High Court judge, which might be £5,000 a day. I was reading about arbitration. Likewise, an arbitrator in America costing 15,000 quid a day. You've got to start to think about, we come back to this appropriate dispute resolution. Well, is £15,000 a day really appropriate? Is that required? I don't know. That's a question for everybody to think about. But certainly, on the basic side of things, where people are requiring mediation help, certainly there should be some sort of state support for that, and that needs to come from the legislation.
John, Esther, we've barely skimmed the surface in this conversation about mediation and legal process, and I, for one, have had a couple of shifts in my own thinking by being part of this conversation today. Sadly, that brings us to the end of this edition of the Resolution Room on mediation and legal process. Many thanks to Dr. Esther McGuinness, Head of the School of Law at Ulster University, and John Keers, Lecturer in Law at Ulster University. And if you'd like to find out more about mediation, or if there's a conflict you're aware of and would like to have resolved, please contact Mediation Northern Ireland at mediationnorthernireland.org. Thanks for listening. We look forward to your company in the Resolution Room for the next edition of this podcast series.